Good afternoon and welcome to the second session of Estate Planning and Power of Attorney series. I can see many familiar names today from our first session. So for those that didn't attend our first session, my name is Matthew Oakey. I'm a director at SW and I'll be moderating today's webinar. Firstly, I'd like to acknowledge the traditional custodians throughout Australia and their connection to the land, sea and community. We pay our respects to their elders past, present and emerging. Today, we'll be discussing the variations and pitfalls of creating a will in the world of a modern family. I'm pleased to be joined by Rahani Bixler from Burke & Associate Lawyers and Heather Dyke, an Associate Director at SW. A couple of housekeeping matters before we begin. We recommend that you click on the Enter Full Screen button at the top right-hand corner to achieve the best webinar experience. Our support team will be answering your questions through the Q&A functions. The Q&A can be found at the bottom of your screen. Please feel free to send questions that you have throughout the session using this function. They will look to answer the straightforward questions as we go, but the more complex questions we might try and leave for the end of the session or come back to you after the webinar. We'll also be circulating the slides to everyone who attends after the webinar concludes. We're having some internet issues at the moment with Rahani, and she's trying to get back online. And Rahani is back online now. So I will like to welcome Rahani to the session. Rahani is a special counsel at Burke & Associate Lawyers who has practiced exclusively in estate planning, deceased estate administration and estate litigation for the last 15 years. She holds a number of key positions on committees that support her commitment and interest in wills and estate law. Rahani has been a full member of the Society of Trusts and Estate Practitioners for 12 years and is Vice President of the Mornington Peninsula Lawyers Association and has held this position till 2013. I'll now hand over to Rahani. So Rahani, welcome back. I'm glad you've got back online. Thank you.
Thanks so much, Matt. That's great. Sorry about that hiccup. Thanks everyone for joining us for the second webinar of this series. As Matt's mentioned, today we're looking in particular at the modern family and will challenges. Of course, there's no such thing as a typical family, especially in today's culture, but the types of things we're focusing on this webinar are blended families, business structures, and trusts. In recent years, one of the most common family structures resulting in estate conflicts are what are often known as blended families. Couples who come together with children from previous relationships may struggle to agree on the balance between passing financial benefits to one another and their children. There's a few ways of managing this balance, and it's really important for each family to carefully consider the options and decide what resonates best with them. As we talked about for those who joined us in the last webinar, one fantastic advantage to having a will is that it can allow you to be creative and to outline your specific intentions about how things are managed after your passing. Where there are substantial assets, it's worthwhile considering immediate gifts to children upon the death of their parent. This way, there's certainty for the children that they're definitely receiving a financial benefit, even if it's not quite the quantity they were hoping for. This strategy can work when there are assets in the sole personal name of each partner, so that the will can directly gift the assets to children upon each person's death. It may also work if the parent has control of a trust and the spouse isn't going to need the trust assets to live on. As indicated in our previous webinar, assets held in trusts do not belong to an individual person and don't pass by a will. We need to look at the terms of a trust deed to see how control of the trust can be passed, and it might be necessary to complete supplementary documentation to pass control of the trust to the nominated beneficiaries. There are pros and cons of this strategy, but it can be particularly helpful if there's any concern about a challenge to the will, as trust can be dealt with outside of the estate. We'll talk about this a little bit more later in the webinar. Another strategy is just to trust the survivor. Many couples prioritise each other over adult children, and don't want to include any provision for the children until they've both passed away. For these couples, they just want to pass everything to the survivor and hope that things work out as they intend in the longer term. They're aware that the survivor, who has received the benefit of all the total combined wealth, may gift assets during their lifetime, change their will to pass assets to only their own nominated beneficiaries, or possibly repartner, leaving their estate open to a challenge from that partner. However, they don't want to deal with this in their own estate planning and are of the view that it'll probably work out. Sometimes people who prefer this option still consider putting into place mutual wills in an attempt to prevent the survivor from changing their will after one person's died. That's really all that does. It doesn't stop the survivor from giving lifetime gifts, and it doesn't prevent the risks associated with repartnering or a challenge to the survivor's estate. It can also create problems if the survivor lives for many years or decades after the first person's passed away and continues to grow their assets during the rest of their life. It can seem like a bit of a windfall to the children of the first partner to die if they still get the same percentage of the survivor's estate, which is now much greater than it was when their parent passed. Where people have a general intention to benefit their spouse for their lifetime and then ultimately to ensure their assets pass to their own children, they often consider the structure of their estate plan really carefully. It may be possible, depending on the structure of ownership, to provide the surviving partner with the full use and benefit of assets and income for their life, but to protect at least a part of the capital, that is, the assets themselves, for the children once the couple have both passed. In this strategy, the ownership structure is really important, which is why we love to have a holistic discussion with the accountant and financial planner in the process of planning for the future. Most commonly, couples in a blended family scenario consider a combination of strategies. For example, superannuation may pass directly to the survivor with no limitations or restrictions in order to maintain the super in a tax-free environment. The family home might be subject to a lifetime benefit so that the survivor can have the full use and benefit of the house, the ability to substitute it for another residence if they need to, but ultimately the children get the benefit of that property. And sometimes other personally held assets in the direct name of each partner might pass immediately upon their death to their own children. So a combination of all three or some other combination that's right for you. Where blended families involve younger children, guardianship can be a particular concern. A parent may want to ensure that their children remain with the current partner if they're still young when the parent passes away. It's important to note that in all cases, whether blended family or not, guardian provision in wills are not binding. They're wishes only, as the best interests of the children are always the top priority. The end result may depend on the age of the children, their own wishes, and whether their other parent is still alive. But in a blended family scenario where children have spent a lot of time with the second partner, if their parent passes away, that partner does have standing to apply for contact with the children, and the will might expressly allow for any legal costs of that application to be borne by the estate. Now we're talking about the modern world, and an increasing number of our clients are talking about how their will impacts their online presence. This area is not clearly regulated, and it's inconsistent depending on the digital asset in question. Social media accounts each have their own rules about whether an account is deleted, memorialized, or removed upon the death of the account holder. The rules are different between sites, and it's really important in particular to be aware of the rules about who owns the uploaded images and other content. Unlike CDs and DVDs, traditionally content within an online account, such as Apple, Amazon, or online games such as World of Warcraft, are Warcraft, are not owned by the account holder, and it's more of a license agreement. So that's going to depend on the service agreement. Changes in this area are starting to take place. Unlike online content, cryptocurrency is recognized as being an asset and is capable of being gifted in a will. It's particularly important for the executor to have detailed records of the type of cryptocurrency, the type of wallet in which it's held, and how to access that wallet. The significant changes to the way businesses operate as a result of COVID is taking more and more businesses online. Some innovators have found ways to generate significant income at home through YouTube accounts. YouTube allows for the nomination of an inactive account manager, and Google does work with executors to deal with the account of a deceased user, including the transfer of funds earned from advertising on YouTube videos. It's also really important to consider how interest in other businesses may pass on death. And Matt's going to talk about that further now.
Thanks, Rahani. Looking at business succession, it's a complex area. And today we'll be highlighting what you should consider at a high level. We would recommend that you discuss with your SW advisor on how these issues impact your business and your personal circumstances. The death of a director. The company's constitution, the Corporations Act, governs what happens when a director dies, and there's different requirements depending on whether the company is a public company or a private company. Public companies generally have more onerous rules, but today we'll focus on private companies. A company may have adopted the replaceable rules under the Corporations Act as its constitution. They're like a model set of rules. However, this is not always the case, and the company may have different rules to the Corporations Act. So it's important to understand how these rules operate on a death of a director. So you need to review your company's constitution. It's important to note that when a director dies, the company can still be managed even if they're not sufficient directors to form a quorum. The remaining directors can make a temporary appointment to make a quorum pending the shareholders replacing the director. And this can be done by an ordinary resolution at a meeting of the directors. There are different considerations to when the company is a sole director, sole shareholder company, and there's special appointment rules in the Corporations Act. These include that the sole director, shareholder's legal personal representative or trustee may appoint a director in the event of the sole director passing away, or the legal personal representative or trustee may appoint themselves as a director of the company in place of the director that has passed away. In terms of death of a shareholder, if the shares are held by an individual, they will form part of their estate. Generally, there are no tax consequences of the company shares passing to a beneficiary, and the normal CGT cost-based rules are applied. So that's if they're pre-CGT, then it's the market value at the date of death of the person. If they're post-CGT, then you acquire the cost base of the deceased person. There are some exceptions to this, and one is CGT event K3, and that's where an asset passes to a tax advantage entity, such as a non-resident or an income tax exempt entity. In these cases, the deceased person is taken to have disposed of the asset at its market value just before they die, and that there may be a capital gain or loss that needs to be included in their date of death return, and the estate would be liable for any income tax payable. There are some exclusions to CGT event K3, where the tax advantage beneficiary is a tax exempt entity and also a deductible gift recipient. The capital gain can be disregarded as CGT event K3 will not be triggered. There's a further requirement to this, and that is should the deceased person still been alive, they would have been entitled to a tax deduction themselves personally. Later in the presentation, Heather will be discussing charitable trusts as part of estate planning. On another note, if the company shares are held by a discretionary trust, there is no direct impact on the ownership because the company shares don't form part of the estate. In relation to Division 7A, where a private company makes a loan to a shareholder or an associate of the shareholder, and no loan repayment is made prior to the death of that particular person, Division 7A does not deem a dividend to be paid to the legal person or representative of the deceased estate. This is because the dividend can only be paid to the person or the entity to whom the loan was made, in this case, the deceased estate. Now, there's a small opportunity here in terms of tax planning, in terms of forgiveness of Division 7A loans, and it would only apply in very limited circumstances. On the date of death of a person, the property of the deceased, including shares in a private company, vests in the public trustee until probate is granted. So that's a state government body. As a result of this, prior to granting probate, there'll be no relevant shareholder for the purposes of Division 7A. So should the private company forgive the loan made to the shareholder prior to the granting of probate, the private company will have not been taken to pay a dividend to the legal person or representative. Now, there's a number of things to work through with this, including giving careful consideration to the ability of the company to forgive the debt. As with the death of a director, you may not be able to establish a quorum to forgive the debt. By forgiving the debt after probate is granted, a private company is taken to have paid a dividend to the legal person or representative as a shareholder. You'll also need to consider whether the commercial debt forgiveness rules or capital gains tax apply. If the loan is private in nature and no interest would be deductible, generally the commercial debt forgiveness rules will not apply. In relation to capital gains tax, you may need to consider the market value or the deemed market value of the loan against its cost base to determine what, if any, capital gain may arise on the forgiveness. Okay, moving on to trusts. So when we're looking at trusts, the key role is the appointer. The appointer has the power to appoint and remove trustees. So it's important to review your trust deed. Many deeds state on the death of the appointer that the control is passed to your legal personal representative. So the question you need to pose is this the person you want to control the trust? You may not. You may want someone else controlling the trust as opposed to your legal personal representative. Now, you can change the appointer through executing a deed of resignation or appointment of an appointer, passing control of the trustee during your lifetime. And for example, if you had a father who set up a business, which he and his daughter now run, and they run that together through a trust, control of the trust can pass to the daughter by deed with the following options. You could transfer the appointership to his daughter now through executing a deed. He could transfer the appointership to his daughter on his death, again through executing the deed, or he could make his daughter a joint appointer and the sole surviving appointer on his death. You can also nominate a successor by will, subject to the terms of the trust deed. Now, one thing some people may not have heard of are guardians and older trusts, and we have many trust deeds that refer to guardians. You may need to consider them because guardians were there to consent or veto significant decisions made by the trustees. The power to remove a guardian is strictly governed by the terms of the trust deed, and this power may already be in the deed, or the deed may be able to be varied to appoint a successor guardian. If neither of the options above are available, the position of the guardian remains vacant, which can lead to problems of dealing with assets and making distributions. So again, important to review your deeds. In terms of family trust elections, an individual that is a specified person in a family trust election must be alive when that family trust election is made. If they pass away, it does not affect the family trust election, and the family group is still defined by reference to that individual. In terms of unpaid present entitlements and loans with trusts, and they're owed to the deceased, they will be debts that the executor will look to collect. And sometimes if there is one single asset in a trust, this can cause some unforeseen issues in terms of liquidity, and maybe that particular asset might need to be sold. In terms of partnerships, When a partner dies, the partnership is dissolved, and this leads to the winding up of a partnership. Although a technical dissolution may have occurred, the continuing partners may continue to run the business with a reconstituted partnership rather than winding up. And although not necessary, a clause in the partnership deed dealing with the death of a partner is good governance and good planning. In terms of small business concessions, now there's a lot in regards to this particular topic, but I'm just going to mention them. The legal personal representative or a beneficiary can apply the small business concessions to a CGT asset within 2 years of the person passing away, the same way that deceased person would have been able to. In certain circumstances, you can apply to the Commissioner of Taxation for an extension of time, and this is done by way of a private ruling. Although I won't go into detail today, these concessions that are available are the 15-year exemption, the 50% active asset reduction, the retirement exemption, and the small business rollover exemption. In terms of business successions, one thing that's really important is buy-sell agreements. And now for a business owner, part of that succession and estate planning should be that you have that in place with the other owners of your business. A buy-sell agreement provides for the transfer of ownership upon the death or total and permanent disability of a business partner. They can be used for companies, trusts, and partnerships. They can also be part of a shareholder or a unit holder or a partnership agreement, so they can be built into those other agreements. You need to be careful using off-the-shelf buy-sell agreements. For example, if you had a partnership of trusts and a person dies, it's not the trust that has died, it's the principal person that controls that trust. So some of these agreements refer to the partner and not the principal person. So you need to make sure that when you have these documents drafted, that they are appropriate for your structure. Buy-sell agreements can cover various life events, including death, total and permanent disability, critical or long-term illness, retirement, divorce, bankruptcy, and major disagreements within the ownership group. Usually they'll have a valuation methodology in there, and they'll have funding options. So whether it's going to be self-funded by the existing owners of the business, or there's going to be buy-sell insurance. Why is buy-sell insurance important? Well, some beneficiaries will not want to be part of the business and will want to cash out of the investment as soon as practical after the shareholder has passed away. And without the insurance in place, sometimes the business or business assets might need to be sold to pay the estate. So you need to understand how it's going to fund the estate. The other issue is it also means that the surviving shareholders in that business will have an increased shareholding and avoid having an unplanned shareholder involved in running the business. That person who acquires the interest in the business may not be have the expertise or the interest in being involved in that business. We're going to come to the first poll for today. And what we would like to know is, are you a business owner? And if so, do you already have a shareholders agreement or a buy-sell agreement? Would you like to have one, or you don't require one? So as people are asking answering the poll, I'll move on to the final topic that I'm going to talk about, which is self-managed super funds and business real property. So where business real property is a major asset within a self-managed super fund, the trustee will need to consider what happens on the death of a member in relation to the payment of their death benefit. And there's some potential issues that could arise, including the loss of control of an asset that is used by a related party, such as a business, as it needs to be sold to an unrelated party. This could also trigger a CGT event, and you could also be a forced seller in an unfavourable selling cycle. There are personal transfer balance caps, and one way of overcoming some of the above is by paying a death benefit income stream. The current transfer balance caps from the 1st of July 2021 is 1.7 million. Prior to that, it was 1.6 million. Other things that the trustees need to consider is diversification. The self-managed super fund may need to accumulate additional liquid assets, such as listed shares, or put in appropriate life insurance policy in place for members to protect against unplanned death benefit payments. The other option could be property transfers, an in-specie property transfer to a beneficiary subject to the trustee. However, this may trigger stamp duty. So you need to be careful there. I'd like to go through an example of this now. So here we've got a self-managed super fund, and the current assets are business real property, so a property of 1.7 million, listed shares of 1.3 million, and cash of 100,000, totaling $3.1 million. On the left-hand side, you can see the current account types. So Joy has an account-based pension of 1.55 million, an accumulation phase of $1 million. Her partner, John, has an account-based pension of 550,000. So the total fund, 3.1 million. So Joy passes away. So what are the options to John? So John could roll back his account-based pension of 550,000 back into accumulation mode. John could then start a death benefit income stream from Joy's $1.55 million account-based pension. So he would then inherit her pension. But what this still means is there needs to be a lump sum benefit of $1 million paid out as a death benefit from the super fund. So because the super fund has got liquid assets there being listed shares or cash, this $1 million could be paid out to John. Now, if the sole asset of the super fund was the business real property, John wouldn't be able to do this, and he might need to dispose of the property to pay the death benefit. Okay. So now I'd like to hand over to Heather. Heather Dyke is an Associate Director of Shinewing Australia. She brings well-rounded skills. Brings well-rounded skills to her clients, offering advice to her clients on personal and business entities on a range of accounting, consulting, and tax issues. Heather also provides these services to large private family groups, charities, and not-for-profit organisations. So I'd like to hand over to you, Heather.
Thanks very much, Matt. Look, there's a number of different ways that you can donate to charities and not-for-profits. We want to provide an introduction to some of the factors you should consider. When it comes to making donations, it can be done both during your lifetime and also through your will. We've included some terms there with definitions, and they'll be explained in more detail as we go through. We've already mentioned deductible gift recipient to some extent by Matt earlier, but I just wanted to explain what that is for everybody's benefit. Any donations to a deductible gift recipient during a donor's lifetime are tax deductible. If the charity does not have DGR status, then generally there's no deduction to an individual donor. There's two main types of DGRs. There's those that are called item 1, which are basically your active charities, those charities that do something, Guide Dogs, Heart Foundation, just a couple of examples. You also have item 2 charities, which are effectively your passive fundraising charities, and these are generally your private and public ancillary funds. Their sole main purpose is to raise funds for active charities. If you're donating to a charity with DGR status, there are some special rules that allow you to spread the donation over 5 years if you cannot get the full benefit in the year in which you make the donation. That's beneficial in your tax planning. If you wish to find out if the charity that you want to donate to has DGR status, you can look this up on the Australian Business Number lookup site. What are the main types of charities, not-for-profits? There's a number of different types, and some of the main ones for your reference are private ancillary funds, and these are trusts that are set up to raise funds from a family group and that then donates to registered charities which have DGR type 1 status. These types of funds are most common types of charities that we see clients setting up during their lifetime and also via their wills. You can have a public ancillary fund. These trusts are very similar to a private ancillary fund, but are set up to raise funds from the public, not from a private family group. They also then donate to charities with DGR1 status. They can be a bit cost prohibitive and complicated to administer. There are health promotion charities, which are primarily to promote the prevention and control of disease in people. There's public benevolent funds whose main purpose is to relieve suffering. And then there's all the other charitable organisations who are registered with the ACNC, and they do a broad range of activities. You then also have not-for-profits, which are not registered charities, and they do not have DGR status. They include things like sporting clubs, community groups, some business associations. When it comes to donating to charities and not-for-profits, there are various ways that can be done. The most common donations are by way of cash, bank transfers, but cash. The alternate is gifting of assets. You can transfer shares, artworks, private assets, trading goods, property to the fund, but there are special rules around the gifting of non-cash assets, and I would recommend that you contact SW consultants if this is something you're wishing to consider. Who should you donate to? It's a very personal decision, but the choices you might like to think about are donating to an established charity. It's obviously one of the simplest options. You could set up a charitable foundation or a private or public ancillary fund. The type you set up will depend on what you're trying to achieve and what the ongoing expectations of the charity are. You could donate to a grant-making foundation, donating to a research institute who then makes grants to researchers, or donate to an educational institute who makes scholarships available to students, generally from the earnings of the funds donated. There are options to also set up sub-funds of community foundations and other existing charitable foundations. If you want to find out more about an existing charity, you can go to the ACNC website. That's the Australian Charities and Not-for-Profit Commission, which has a lot of information about all registered charities. Some factors to consider who you may donate to. What's the main goal you're trying to achieve? It's always a good starting point. Do you want to have control over the spending of the funds? Are you wanting to get a tax deduction for the donation? Do you have a clear understanding of the timing of the gift? Will it have an immediate impact, or is it to be a long-term enduring legacy? If you set up your own charity, some of the things to consider in setting it up in succession would be, do you want to set up an active or a passive charity? Depending on the type of charity, there are specific requirements as to the minimum number of people involved and what structure type it should be. For instance, a private ancillary fund, which is a common charity we set up for families, has to have a founder, a corporate trustee, and one of its directors must be a responsible person. That is a person other than the founder or family who meets the ATO guidelines. For instance, lawyers, accountants, doctors, a number of people at SW can and will act as responsible persons. Providing for succession is very important. You need to think about who takes over from you as directors of the trustee company, if it's a private ancillary fund. You may wish to consider bringing your children in as directors so that they can provide continuity going forward. Think about what stage is best to do that. Who takes over the shares in the trustee company, and provide for that in your will. Is there a time frame for the existence of the charity? Should you gift during your lifetime through your will, or maybe both? It's a personal decision, but I'd like to just go through a few factors that you might think about in making that decision. During your lifetime, being able to witness the beneficial work that is achieved by the charity is quite rewarding. Having control over the programs and services and how the money is spent on them. And the other thing you have is that charity has been granted DGR status. You could get a tax deduction, effectively increasing your net after-tax funds available. If you wanted to do it through your will, you can retain the use of your funds during your lifetime. Donations through your will, though, are not tax deductible. If you're donating directly from your will to an existing charity or to a trust to be created as part of the administration of the estate, please consider whether it should be a specific sum, a percentage of the estate, the balance of your estate, or maybe a specific asset. Your executors or family may not have time to dedicate to the management of a private charity. Therefore, gifting to established charities through your will may be an option. If setting up a charitable trust under your will, please consider the following. The process to set up a charity as part of your will is very similar to setting up one during your lifetime. The application process is done through the ACNC, the Australian Charities Not-for-Profit Commission, and they're responsible for managing all registered charities. The will should specify things like what type of charities to be set up, who the trustees will it be active or passive, who should benefit from the charity. This can be in the form of guidance or be more specific if particular charities are to benefit. If you're being specific about the charity, you need to be very careful because charities do change over time. Sometimes they merge, change names, cease to operate, so you need to be careful in that space. Who's to run the charity, including ongoing succession of management and trustee. Any charity that is created by a will won't at the date of death won't exist at the date of death, and therefore it will not have DGR status at that time. Therefore, there are potential capital gains tax implications that will apply to the deceased estate if assets other than cash are transferred to that charity. If you are in this situation, steps ought to be taken immediately to seek DGR status for the charity prior to the transfer of any assets. There are obviously options to do donations both during your lifetime and add to them through your will. If you've set up your private ancillary fund during your lifetime, you can certainly add to that through your will. But again, succession is important. Consider who will take over control of the fund once you pass away, and is that something that you should transition during your lifetime? We've had a fair bit of experience setting up charities, in particular private ancillary funds. So if you have any questions or are interested in this, reach out to your SW consultant. We're now going to do a poll question, which will pop up on your screen. Whilst you're answering the poll, I'm going to thank you and hand you back to Rahani for the next stage. Thank you.
Thank you so much, Heather. That's really interesting. And thanks to those who are currently answering this poll. As Heather mentioned, you can donate to charity either during your lifetime or through your will or both. And when we're talking about will challenges, unfortunately, gifts to charities within wills can potentially be subject to challenge if you do have family members who would prefer to get the money themselves. And it can be really awkward for the charities to fight to keep what was intended for them. So it is, it's always nice to see people doing lifetime giving where they can, obviously not always an option for everybody. So talking about will challenges, how can we avoid them? There are a few common scenarios which lend themselves to estate litigation, that is, challenges to wills. Blended families, as we outlined earlier in the webinar, is one of these scenarios. Another common scenario involves family businesses or family farms, particularly where one of the children has worked in the business or on the farm and others haven't. and any other potential scenario in which beneficiaries are treated unequally or have significantly different situations. For example, if one child has a disability and the other two are multimillionaires, an equal distribution from the estate might not be fair. There are a few strategies to minimise wills. Some families broach the subject early through family conferences to manage expectations. Management of expectations can certainly help to reduce estate challenges, but may not always avoid them, as sometimes family members are reluctant to raise their concerns during the lifetime of the will maker. Another way, other than in New South Wales, where different rules apply, is to try to reduce the assets owned personally. People challenging a will can only really access assets which are solely and personally owned by the person who made the will. If they don't have anything in their name, there's nothing in the estate to challenge. As we've discussed earlier, assets held jointly pass by survivorship to the surviving joint owner. Assets within trusts do not form part of the estate to pass through a will, although we do need to look at control provisions. Where the control passes to an executor, that may become an issue. Superannuation death benefits might be passed directly by way of a binding death benefit nomination if you have an appropriate beneficiary. Sometimes you might not have someone who qualifies as a superannuation death benefit beneficiary, and there's no option but for them to hit the estate. If you're worried about someone possibly challenging your will, it's important to talk this through with your advisors, have a look at your structure, and try to use ownership to minimise the value of the estate available for challenge. We're just going to finish off by talking about a couple of recent cases that have been particularly interesting and actually go against some of what I've just been talking about. So one recent case was the estate of Bob Hawke. In this estate, the will attempted to follow strategy 1, if you can remember back to earlier in the webinar, talking about immediate gifts to children. So this was a blended family scenario, and in the will of Bob Hawke, he gave immediate gifts of $750,000 to each of the children, with the balance passing to his second wife. But one of his daughters decided that, or claimed that, $750,000 wasn't enough to meet her living expenses, and she submitted a claim for $4 million out of the $18 million estate. The claim did settle at mediation. Interestingly, the bulk of this estate was the family home in Northbridge. In states other than New South Wales, if the home was held jointly between the will maker and his wife, or even just in the wife's name, it wouldn't have been part of the estate, wouldn't have been available for challenge, and that value of the estate would have been substantially minimised, and a $4 million claim would have been unlikely to be successful. However, in New South Wales, notional estate rules, which are different from other states within Australia, can potentially open up assets held outside the sole personal name of the deceased to a challenge. Now, the other recent case that we're just bringing to light is the case of Joss and Joss, which was a Victorian case. This was really interesting because the claim was from one of the children of both the deceased and the surviving spouse. So this was not a blended family scenario. This is really unusual, as generally the traditional family structure doesn't lend itself to will challenges. The children expect that they're ultimately going to benefit anyway. A few things led to this claim being somewhat successful. The plaintiff got about $3.2 million, which was less than she'd asked for, but still a substantial amount. The estate was over 12 million, and the widow had significant additional assets in her own name. There was also need that was demonstrated by the plaintiff that was an immediate need that potentially based on the evidence that she presented, which the court accepted, indicated that it wasn't reasonable to keep her waiting, that this would have such a substantial impact on her life immediately and was needed to be gifted straight away. And also that the mother who was surviving may not have substantially benefited the plaintiff from her will down the track. So it was a very interesting fact scenario, but it just goes to show that every estate challenge matter is heard on its own facts, and particularly where the estate is large and some form of need is demonstrated, immediate gifts to children are a possibility of being ordered. I'm just going to hand back to Matt now to go through the results of the polls and a few questions that have come through.
Thanks, Rahani. So in relation to the polls, I'll just go through the first poll. And it was, we were looking at whether or not you were a business owner. And if you were a business owner, whether you already had a shareholder agreement or a buy-sell agreement. So 7% of our attendees are a business owner with a buy-sell agreement. We have 3% that would like to get these agreements in place. 14% said you're a business owner but don't think you need these. And 76% of people are not a business owner on this webinar. We do have a lot of private clients within this webinar. The second poll is in relation to charitable trusts and whether or not you, or bequests, whether or not you would consider leaving a bequest in your will or set up a charitable trust. And 12% of you have, 38% of you would like to, or sorry, 38% of you would not consider that, and 50% of you would consider it. So around 62% of people would have either left a bequest or set up a charitable trust or would like to. We do have some Q&A questions. And the first one is on what I mentioned before in regards to Division 7A and the granting of probate and forgiving the loan prior to that. And it's would Part 4A be an issue if the Division 7A debt was forgiven before the granting of probate? In relation to that, with any Division 7A issue, you need to carefully consider the individual facts of each circumstance. And maybe if there was an inability to repay the debt, this might be considered acceptable. Now, what we do know is that the ATO have accepted some arrangements and there are private rulings on this. I'm just
Shall
looking.
Sorry
yes,
to jump in that. There's another question here that says, where there is a traditional family and there's an estranged child with restraining orders against them, would they have a chance challenging a will where they're given nothing? Now, that's really interesting that you've asked that question, because that is actually very similar to the Joss case. So usually a restraining order would indicate that there was some disentitling conduct. So where you've got an estranged child, you can demonstrate that that usual moral obligation for a parent to provide for their child has been reversed by the child's conduct, such that they've disentitled themselves to any benefit from their parent's estate. But in the case of Joss, the plaintiff child had actually made plans to kill her father, and the plans were shared with a number of people, were designed to publicly humiliate him and his wife, the mother, on the steps of their place of worship. So I would call that ordinarily disentitling conduct. And on the face of it, that would be someone who you would often say they probably don't have a strong chance in challenging a will that leaves them nothing. And there was a lot of evidence around that, and the deceased had even done supplementary documentation around the story of the relationship and everything that the child had done to disentitle herself from benefiting. But sometimes when you hear the other side of the story and that's presented well to the court may say, we can understand the context of that conduct. So it's very much case dependent and fact dependent. And I would say how well it's argued on each side to the judge, and if it hits the court.
Thanks, Rahani. Thanks, Rahani. While you're there, we've got another question here. Is so if someone's eligible to challenge the estate, who pays the legal costs?
Yeah, that's a great question too. And again, it really depends. So if most estate challenges do settle, if you're eligible to challenge, the large majority of them settle at some point before they get to trial. And if they settle, the legal costs are usually negotiated within that settlement. But for those matters that go to trial, there's no certainty about who pays the estate. There's actually a costs award from the court. If the court decides that the case was reasonably brought and everyone's behaved reasonably along the way, they're likely to order that the costs of everyone's legal fees, if those legal fees are reasonable, are borne by the estate. But everyone needs to enter that scenario assuming that they could have a costs order against them.
Thanks, Rahani. And I've got another question here, or we've got a few questions on cryptocurrency, so we must have a bit of a younger generation here. But Heather, can you donate cryptocurrency?
Yes, you can donate cryptocurrency. It would be treated similar to donating shares to a charity. So it will potentially trigger a CGT event in the hands of the donor. And there would have to be a valuation put to the transfer, and that would be the value that would be assigned to it from the point of view of a deduction if it went to a charity with deductible gift recipient status.
Thanks, Heather. And I've got a question here on cryptocurrency. Do I need to pay tax on inherited cryptocurrency? So cryptocurrency is a CGT asset. So it's treated like any other CGT asset. Obviously, you won't have any pre-CGT cryptocurrency because it wasn't invented prior to September 1985. So if you do inherit it, you'll inherit the deceased person's cost base. And then if you dispose of that, you may have a CGT gain or loss. So I think they're all the questions we have at the moment. So I'd like to thank everyone for attending today. I'd like to thank Rahani and Heather for their insightful presentations. And I'd like to thank Stephen, Robin, Keegan and Taylor for assisting with the Q&A today. I'd also like to thank Lucy and Madeline, part of the marketing teams for Burke and Associates and SW. They have been fantastic, and without them, this wouldn't have been able to go ahead. And if you do have any questions after the webinar, please speak with your SW advisor or your advisor at Burke and Associates, and we can get back to you. We also value your feedback on the session, so please complete the feedback survey, which will pop up on your screen at the conclusion of the webinar. And we look forward to welcoming you to our final session, which is in October, which is discussing power of attorneys. And you can follow us on LinkedIn for registrations and more information. So I'd like to thank everyone for joining us. Stay safe, stay healthy, and we'll see you soon.